Assalamualaikum and hi everyone. So today I would like to tell you about the obligation that need to comply by the member states in patenting the microorganisms under the trade related aspects of intellectual property rights (TRIPS). Together with me, Muhammad Zulzarif and Vinayjit Singh will explain about this topic. So first of all, my name is Izzat Fakri bin Halimi. Before we go through to the detail of this topic, let's see the definition of the microorganism first. A microorganism is an organism that is microscopic, which can be considered as small enough to be seen with the naked eye and can only be viewed under a microscope. Bacteria, fungi, archaea, and protists, as well as small plants like planktons and organisms like amoeba, are all examples of microorganisms. Microorganisms are defined by the European Commission (EC) regulation as any cellular or non-cellular microbiological entity capable of replicating or transmitting genetic material. According to EC directive, biological material is also defined as any material having genetic information and capable of replicating itself or being replicated in a biological system. Next, we move to the essential criteria for patentability. A patent is an exclusive privilege in the form of a monopoly right granted by the state to the inventor or assignee in exchange for full disclosure of the invention for a specific length of time. For the duration of the patent, which is normally 20 years from the filing date, a patent gives you the right to prevent anyone from creating, using, selling, offering for sale, or importing the patented invention. Because a patent is a monopoly right, it must meet the key criteria of innovation, non-obviousness, and usefulness. The Agreement on Trade-Related Aspect of Intellectual Property Right, TRIPS, aims to reduce trade distortions and barriers by providing effective protection for IP rights. It establishes a set of minimum requirements that all member countries must adhere to. Patents are accessible for any invention, whether items or processes, in all disciplines of technology if it is new, involves an inventive step, and is capable of industrial application. The phrases new, inventive step, and capable of industrial application are not defined in TRIPS. In patent terminology, new refers to something that has never been made available to the public. Members can exempt commercial exploitation from patentability if it is required to protect human, animal, or plant life or health, or to avert substantial environmental harm. Patents must be available and patent rights must be enjoyed regardless of the place of discovery, the field of technology, or whether items are imported or produced locally. As a result, this provision satisfies the three requirements of originality, non-obviousness, and utility. The essence, however, is non-discrimination, as patents will be available for any invention regardless of technical field. Thank you, that's all from me.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Zulzarif. My matrix number is 056391. TRIPS agreement is the most comprehensive multilateral agreement on intellectual property to date, concerned that rich countries were insisting on an extremely restrictive interpretation of TRIPS. Developing countries convened a round of discussions in 2001 that resulted in the Doha Declaration. The WTO's Doha Declaration clarifies the scope of TRIPS, noting, for example, that TRIPS can and should be construed in light of the purpose to ensure universal access to medicines. Number 1. WTO members must provide copyright rights to the authors and other copyright holders, as well as holders of related rights, such as performers, sound recording producers, and broadcasting organizations. Also, geographical indication, industrial designs, integrated circuit layout designs, patents, new plant varieties, trademark, trade names, and undisclosed or confidential information. According to TRIPS, TRIPS also lay out the method for enforcing the agreement as well as remedies and dispute resolution. All intellectual property right must be protected and enforced a way that promotes the technological innovation, technological transfer, and dissemination to the mutual benefit of producers and users of technological knowledge, and in a way that it is conducive to social and economic welfare. As well as a balance of rights and responsibilities, the main requirement of the agreement includes that the copyright terms must extend at least 50 years, must be granted automatically, and must be granted for inventions in all field of technology provided. They meet all other patentability requirements. With the exception of moral rights, the TRIPS agreement contains by reference the provision on copyright from the Berne Convention for the protection of literary and artistic works, the fundamental articles of the Paris Convention for the protection of industrial property were also adopted by reference. Software and database are particularly mentioned in the TRIPS agreement as being protected by copyright, subject to the need of originality. With respect to microorganisms, in the TRIPS agreement, Article 27 is the appropriate provision in terms of living material. Article 27 Clause 1 establishes the fundamental obligation that member states offer patent protection for all sorts of inventions regardless of technology field. Article 27 additionally provides three categories of optional omitted material in acknowledgement of the fact that many earlier patent systems featured specific categories of banned materials. These are inventions that would be morally wrong to commercialize. For example, inventions that are diagnostic, therapeutic, or surgical procedures for humans or animal and plants. Member states may not exclude microorganism or non-biological or microbiological process from patent protection. As previously indicated, this is due to the fact that pharmaceutical industry's substantial use of microorganisms and its dependency on patent system to guarantee protection for the findings of its investment-intensive research. Plant varieties shall also have either patent protection or a sui generis right pursuant to member states. So that's all on the TRIPS agreement. Thank you.
Moving on, I will now explain on Malaysia's position on patenting microorganisms. Malaysia's stance is expressed in Section 12, Clause 1 of the Patents Act, which establishes a test to determine whether the subject matter is an invention. According to Section 12, Clause 1, the alleged invention must be used to solve a specific problem. This implies it isn't an invention until it can be demonstrated to be a solution, as the law demands. In general, in order to prove the subject matter as a solution, one must reduce the idea to practice it. Otherwise, by filing a paper patent without having actually made the invention, the inventor is speculating or guessing about the features of an invention that has not yet been built, thereby failing to support the application. Since the procedure for recombining DNA is well known in gene patents, the only way to pursue patentability for products is to meet the solution criteria for a specific problem. Because the inventor had not dedicated his thoughts to the specific problem, which remains unsolved, a failed solution must be rejected under Section 12, Clause 1. These may be real concerns that patenting biological materials does not meet the criteria of an idea, and so is ineligible for inclusion in the field of technology, despite the invention restriction in Section 12 Clause 1. Section 12 Clause 2 further restricts its application to product or process. This is typically not a problem because man-made microorganisms are considered living products or claim a process for creating such. It is widely assumed that a literal reading of Section 13 Clause 1 of the Patents Act would allow patenting of man-made living microorganisms. microbiological processes, and also the product of such organism processes, as well as products used in methods for the treatment of the human or animal body by surgery, therapy, and diagnostic methods which are used on the human or animal body. This might imply that naturally existing microorganisms will be discovered, but not man-made living microorganisms. Malaysia simply specifies that man-made living microorganisms, microbiological processes, and the product of such organism processes are patentable under Section 13 Clause 1b of the Patents Act. Although there is no specific mention of barring nature's contribution, discoveries are a limitation to patentability in Section 13 Clause 1a. This phrase refers to discovering anything that exists naturally in nature and is frequently used to challenge biotechnology patent. In contrast, it is not a discovery if one makes a living microorganism that is not present in nature at the moment. Following the approach of Diamond against Chakrabarti in the light of Malaysia's clear man-made aspect, the degree of human intervention necessary to differentiate between an intervention and the finding is likely to be at the heart of any dispute. When a product is used for treatment, surgery, therapy, or diagnostic reasons, the more intervention by humans, the more probable patentability will be supported. Rather than the synthetic microorganism, such intervention might be the manufacturing process, which is the subject of the claim. However, just because something qualifies as patentable does not imply it will be given a patent. It will still require the demonstration of a new inventive step as indicated in Section 14 and 15 of the Patents Act. That's all from me. Thank you.